Hello, my name is Brant Hunt. My channel is Discerning What is True. Today is the fourth day of March 2023, and I am also broadcasting on YouTube and also on Odyssey tonight. And my title of my show tonight is The Rape of Justice, Chapter 3, Part 2. This is coming from Eustace Mullins' book, The Rape of Justice. He wrote this book in 1989, and he has a lot to say about lawyers, indeed. So let's get into the meat of the book. Hope you have ears to hear and eyes to see tonight. Okay? This chapter's named a Plague of Lawyers. The appearance of the ABA as a genuine national force first came in 1909 when a group of British lawyers arrived in Chicago to set up a monolithic organization. They were actively assisted by John D. Rockefeller, who was then setting up the University of Chicago to promote the principles of British Fabian socialism with a gift of $50 million. The Illinois legislature then passed a statute that only members of the legal union, that is the ABA, would be allowed to practice law within the state. So this is how they're gonna take over here. Okay, let's give you your history. That is Mr. Mullins is. With this act, the state of Illinois, for all practical purposes, seceded from constitutional union of states by granting special privileges in violation of the Constitution. This statute also set up a class system in the United States. Other states were persuaded to adopt the Illinois statute, that is, in California in 1927, this took place, and the other states took place in the 1930s until the ABA had achieved its goal of national power. Yale lawyer Professor Fred Rodell characterizes the union members of the ABA, the duly licensed and chartered lawyers, as purveyors of streamlined voodoo and chromium-plated theology, whose weird and wordy mental gymnastics enable them to carry on a high-class racket. There are now some 180 approved law schools in the United States. 180 of them. And this took place in 1909, starting in the state of Illinois. And obviously, John D. Rockefeller wanted this to happen, you see. Although the missing 13th Amendment, which was passed legitimately by three-quarters of the state, is they actually it's gone. It's no longer there. Most people are not aware of that. This is a guy named Dave Dodge who wrote this. Go and look at the look at the information. The missing 13th Amendment. It's there. It was passed. And then under Lincoln's administration, it disappeared. Continue. On graduation, these lawyers are still mere apprentices, that is, because they have been taught little or nothing about how the legal system actually operates or what a lawyer must do to earn his fees. They are not taught the classics of law, such as the works of Coke, C-O-K-E, and Blackstone, but they endure months of systematic quibbling about the law of contracts or the meaning of a household. This is to prepare them for the practice of the law merchant. This is the name of the book. I think it's called The Law Merchant by Fred Rodell. During some 40 years of research into the problem plagued this nation, the present writer dug down to the strata of a common plateau, which reveals the simultaneous origins of the various forms of criminality infesting this land. It has begun with a small fraternity of international bankers who first fastened their central banking system onto the nation of Europe, and later in the secret meetings at Jekyll Island, Georgia in 1910, conspired to create a Federal Reserve System, which was not federal, has no reserves, and was not a system but a syndicate. These are criminals, folks. This is what they are. They're all criminals. In the world order, I revealed the tentacles of the financiers which manipulated the governments of the world. I proved that the three professionals which were doing the most damage were the bankers, the lawyers, and the doctors. Kind of almost goes with scripture, doesn't it? Except that Jesus spoke out against the temple, the system, which is actually interesting too. And then they supposedly said that Jesus and Christ and all that stuff. Anyway, educators came in a strong fourth, that is, and murder by injection, that is. I expose the medical profession and the present work. I expose the legal profession, despite its functions as a legal octopus whose fierce squirting of black ink confuses and subdues its prey. In all of these works, I have found myself dealing with essentially the same families and the same groups, but both within the United States and abroad. A recent television expose of Dr. James Burt, who had for years performed strange sexual operations on his women patients with the knowledge of his peers, carried the official disclaimer of the medical profession from a prominent physician. Of course, the other doctors knew what he was doing, but they wouldn't dare expose him. He might sue them, you see. And no one wants to get involved in that horror, which is our legal system. The lush profits from malpractice suits have made the medical field easy pickings for the legal vultures, while discouraging conscientious doctors from adequately treating their patients. The result is intended to be the final socializing of all medical practice in the United States under the total control of the government. The ABA carries considerable weight in the operations of a legitimate process. The resolution of the 74th Congress, that is on August 27, 1935, of the Joint Resolution Joint Resolution consenting to a interstate oil compact to conserve oil and gas would have not been possible without the ABA, whose members drafted a Federal Oil and Gas Conservation Act in 1935, subsequently passed a state law in South Dakota in 1955, and later in other oil-producing states. This drive for conservation was intended solely to protect the oil monopoly of the Rockefeller industry and their many subsidiaries, that is, it forbade newcomers from drilling so as to control production and maintain high price levels. This program was originally formulated at the ABA annual meeting in Seattle in July of 1928. An act was written which removed the major oil companies from the control of the antitrust laws. I didn't know that, folks. Volume 53, pages 72 through 89. In 1934, the governor of Texas, who just happened to be the president of Humble Oil, that is one of Rockefeller's main acquisitions, used this ABA Act to call out the National Guard, stopping further drilling by independent producers. Wow. Unbelievable, folks. Just unbelievable. Congress was then ordered to draft national approval of this act by the Joint Resolution Act of 1935. The ABA maintains a number of active subcommissions which constantly review and redact laws controlling the daily lives of all Americans. Their recommendations, like their approvals of candidates for judgeships, are always accepted by the pertinent congressional committee as worthy of being drafted into law without changing so much as a comma. Yet, no citizen has ever elected any member of an ABA commission to national office. Typical of these secret commissions in the ABA section on patent, trademark, and copyright law, which was exposed in the Senate Judicial hearing of February 3rd, 1974, under the title "The Organized Bar: Self-Serving or Serving the Public." The committee found that the incoming chairman of this influential ABA section was Theodore Bowles, a member of a secret ABA operation known as the Tuesday Group. Bowles was a former general patent counsel for the Westinghouse Corporation and a prominent Washington lobbyist, that is, in the field of patent law. The Tuesday Group was a clique of lawyers which drafted the Scott Amendments, proposals which would exempt many present illegal patent practices from the antitrust laws. The Tuesday Group then persuaded Senator Hugh Scott to introduce them on the Hill. Scott was a Washington politician who enjoyed many of the perks of a prominent political figure. He was able to indulge in his penchant for collecting priceless Chinese antiques, a hobby which was beyond the means of most of his colleagues on Capitol Hill. Wonder why. The Judicial Committee found that other ABA sections were headed by lobbyists from leading corporations. The chairman of the Environmental Controls Committee of the ABA comes from a large Richmond, Virginia law firm representing Humble Oil. Three power companies, 3 railroads, General Motors, a gas pipeline company, and a chemical corporation. He seemed an ideal choice to draft regulations on pollution. The Judicial Committee further stated the Coal Committee of the ABA is headed by a lawyer from Consolidated Coal Company. His vice chairman is a lawyer for the National Coal Association. The Oil Committee chairman, the General Counsel of City Services, and his vice chairman is General Counsel for Hummel Oil. The Forest Resource Committee of the ABA has a chairman whose law firm represents Georgia Pacific and Moore Oregon Lumber. The vice chairman law for representing U.S. Plywood and Champion Paper, etc. No wonder the average person in America struggles. These are fucking thieves. The entire Senate Judicial Committee reported is a fascinating expose of the intrigues in which lawyers engage to protect the profits of their clients, while these firms defraud and injure the American public. The ABA also takes strong public positions on many political issues. The entire organization unhesitantly endorsed the Equal Rights Amendment in the confident expectation of generating billions of dollars in extreme profitable lawsuits. Indeed, it was the fear of an avalanche of lawsuits which finally caused the ERA to be defeated. This one amendment would have paralyzed an already overburdened court system. Much like the AMA, the American Medical Association, which is also headquartered in Chicago, the enormous influence exercised by the American Bar Association lies in monopolistic practices. It controls the means of entering the profession by controlling the accreditation of law school, just as the AMA did too, just like it did about Harry Hotsey. Same thing, folks, same thing. Controls the accreditation of medical schools and hospitals. In all but 2 states, Georgia and California, the would-be lawyer must attend an accredited law school that is accredited by the ABA before permission is granted to take the state bar examination, which is also prepared under the supervision of the ABA. Legislation is now underway in California to end the opportunity for non-accredited students to take the bar exam in that state. The bar exam prevents anyone from practicing law, even though Robert H. O'Brien, chairman of the California Committee of Bar Examiners, admits that the bar exam does not accurately predict the ability of future lawyers. Those who pass are then admitted to the Integrated Bar Association, that is the state monopoly, which has the power to punish any attorney who fails to conform to its stringent controls. So you see that it's all again. For years, the state bar associations had operated in open defiance of antitrust laws, conspiring to fix fees, prohibiting advertisement by attorneys. That's true. There was no advertisement on TV, folks, with attorneys, and prosecuting anyone accused of unauthorized practice of law. Competency is not an issue. The bar monopoly can and does prosecute highly skilled legal practitioners such as paralegals, trust officers, and others whose skills and experience more than qualify them to practice law. The ABA particularly frowns upon anyone who is labeled a tax protester by the vigilant agents of the IRS who criticize any persons or institutions of the establishment. Although the ABA tries to present a public figure of a stern moral entity which prosecutes and punishes any attorney suspected of moral turpitude, judges publicly know to have accepted bribes have been elected presidents of bar association. A ABA panel commissioned to look into the discipline situation among lawyers in 1970 sums up its findings in one word: scandalous. Although few Americans are aware of the ABA and its sinister machinations, its conspiracy affects the daily cost of living for every American. The ABA strongly urges the extension of state powers over the lives and properties of every American, whether one wishes to call this Marxism or 1984 or communism. It most definitely is not American, nor is it the republic for which we stand. For this reason, there is now rising opposition to the ABA and the monopoly which is exercised over the practice of law. In Austin, Texas, Daniel Madison has filed a suit against the ABA, the Texas Supreme Court, the University of Texas Law School, and the Law Students Council for violation of the antitrust laws, and for conspiracy to keep power from non-lawyers. Madison explains his suit with these words: if you're rich, you can have all the justice you want, but if you're a working class citizen, you may get little or none. That is the system here in America. The precipitous deadline in American production and export income has been ascribed to many factors such as poor American workmanship, the strength of the dollar, and other factors. However, only one scholar, that is Peter Huber, Huber, has dared to put the blame where it most plainly lies in his fully documented work called Liability, the Legal Revolution, and Its Consequences. He tells us that the tort law was set in place in the 60s and 70s by a new generation of lawyers and judges. Some grew famous and more grew rich by selling their services to enforce the rights they themselves had invented. Although a few Americans may have been pleased by the enormous settlement won for them by their lawyers against American manufacturers, the overall result has been devastating. More than $30 billion a year is now spent on such lawsuits, according to a recent study by the RAND Corporation, which the RAND Corporation, most people are not aware of, is a think tank, with more than half of the sum going to attorneys as fees. Huber says that the industrial habit wrought by this practice accounts for 30% of the price of a stepladder and 90% of the price of childhood vaccines. He writes that the amorphous new jumble of contract and tort law called contort law overrules our most important economic freedom, the freedom to make advanced commitments and to arrange deals on terms mutually agreeable. Writing in the Wall Street Journal, that is September 28, 1988, he recites the reluctance of insurance companies to write liability covers at any price, the concurrent decline in overall safety as new technologies are withheld from the market, and the decline of American competitionism in foreign markets. He said U.S. contort law gives foreign manufacturers an important competitive edge. Hewitt has found that tort law costs the American consumer $300 billion a year. The overall verdict of Hewitt's book is that there has never indeed been a revolution in liability cases, with the result that in the past 30 years, tort law, the law of accident and personal injury cases, has been altered by judges and law professionals to make the law more compassionate and more anti-business, that is, a logical result of the growing Marxism of the American bench. The result may be seen on every hand in the rapid obsolescence of the Rust Belt, the growing deficit of the U.S. balance of trade, and the growing foreign investment in the United States. In 1988, it had grown to $304 billion, which includes 33% of chemicals, 12% of all manufacturing in the U.S., 12% of printing and publishing, and 10% of fiber and textile manufacturing. Huber is not the only one to attribute this tragic decline in American assets to the malignant depreciation of our legal profession. Huber recommends as a first step the repeal of the judge-invented collateral source rule, thus relying on direct insurance of goods and services. And it is unlikely that the judges will back down from the dilemma which they themselves have created, or that the insurance companies could afford the vast amounts required for direct insurance coverage. Whatever the outcome, the situation can be traced all the way back to Starkey, S-T-A-R-K-E-Y, APT Act opposition during the reign of King Henry VIII. Everyone that can color reason, make it a stop to the best law that is in before time devised. The excesses of tort law are the consequences of earlier abuses by lawyers in the early years of the century. Lawyers usually act as claim agents for companies facing a damage suit, that is, using their talents to persuade a victim to sign a release on payment of minimum damages. This practice backfired when the lawyers realized that they could make much more money by representing the victim against the companies, extracting huge settlements of which they took 1/3 contingency fees plus untold expenses. The practice was little more than ambulance chasing, that is, but it proved very lucrative. The red lights of the ambulance still proved to be an irresistible attraction to the legal profession. The Wall Street Journal headline in September 1st, 1988, the Texas bar rushes to crash site to protect victims from certain lawyers, attempting to protect victims' family from solicitation by unscrupulous lawyers. The State Bar of Texas rushed in on lawyers to the site of the Delta aircraft crash at Dallas International Airport. The article notes that the solicitation by lawyers is a crime, usually a misdemeanor known as barratry, B-A-R-R-A-T-R-Y. On February 16, 1989, the Wall Street Journal memorialized, that is, the dozen of lawyers who raced to, that is, Bhopal, that is in India, Bhopal, in the days after the accident, and later brought the victims' cases to the U.S. court. The mad whirl, as respects to the lawyers' rush to Bhopal was occasioned by the tempting prospect of thousands of clients when the Union Carbide plant in Baclay had a gas leak in 1984. The lawyers actually signed up thousands of clients, but were thwarted when the Indian government assumed control of the litigation in 1986. Union Carbide agreed to a 470 million a settlement with payment to the registrar of the Indian Supreme Court. This apparently left the Americans' lawyers in limbo, as they would have no access to the funds. In tort action, it is axiomatic that the lawyers take his payments off the top. It is unlikely that Indian bureaucracy will be willing to share the loot, most of which will probably never reach the victims. For the Baclay flyers, it may be a bitter pill. Louis Button, that is Button, the French lettering good manufacturer, developed another new angle on the attorney problem. Instead of continuing to hire lawyers to battle against counterfeiters who illegally put the Button name on their products, Button has now prosecuted more than 50 cases in New York by having judges appoint corporate counsels as special prosecutors. These counsels then launch criminal contempt proceedings against offenders who violate court injunctions against counterfeiting, because such counterfeiting is now a $5.5 billion a year problem. Other manufacturers have followed suit. They have shifted their costs onto the shoulders of the public prosecutor because they have notified him of the commission of a crime. It is then his duty to prosecute it. However, when the present writer had done this in the past, the government agencies had refused to prosecute. No action has ever been taken on notification of serious violation of law, that is. The legal profession continues to make its fees from public misfortunes. When the A.H. Robbins Company of Richmond, Virginia, marketed a faulty uterine device that is called the Dalkon Shield, the Dalkon Shield, some 195,000 women who were injured by it filed claims for the injuries. The firm sought protection under the Federal Bankruptcy Act, but eventually set up $2.4 billion in funds to settle the flood of personal injury lawsuits. In September 1988, a confidential report concluded that a major Wall Street law firm, that is Cadwalader and Wisham and Taft, as in President Taft, violated conflicts of interest laws in an interpermissional appearance of impropriety by simultaneously representing a committee of Robbins plaintiffs and the 5 trustees who will be dispersing the billions in settlements. The Cadwalader firm was said to have played the principal role of nominating 4 of the 5 trustees. Millions of dollars of potential revenue for the Cadwalader firm are at stake. The national crisis among the savings and loan banks has been explained by the involvement of lawyers in the long-standing campaign to deregulate them. Those same lawyers are now stepping in to write proposals for resolving the problem. The Wall Street Journal noted on January 31, 1989, that Thomas Vartanian, Bartanian, the former general counsel for the Federal Home Loan Bank Board, wrote the laws which deregulated the thrift banks after they went bankrupt as a result of that deregulation. He joined the New York powerhouse law firm of Frank, Harris, Shibler, and Jameson. The firm earned some $12 million in 1988 by handling 55 thrift mergers. Varnican, deputy at the FH, the Federal Home Loan Bank Board, Patrick Doyle, who also has built up a thriving saving and loan business at the Washington law firm of Arnold and Porter. Washington remains the preeminent home base for the lobbyists, though. Some 11,000 now holding court there. The dean of Washington tax lobbyists is Charles Walker, whose CEW association represents a powerful corporate base known as the Group of 14. These 14 major corporations include Alcoa, which is the Aluminum Company of America, AT&T, Bechtel, Champion, Dresser, DuPont, IBM, and others, with aggregate sales of $260 billion a year and employment of 2 million workers. They depend on CEW associates to handle tax code changes which will affect their profits. Walker came to Washington as the protege of Robert Anderson, that is Secretary of the Treasury from 1957 to 1960. Walker became overseer of congressional relations for the Treasury Department, later writing the Tax Reform Act of 1969. He earned a valuable reputation as the man to see if you wanted something done in Washington in the tax field. His firm now makes millions per year. His mentor was Robert Anderson, was not so fortunate. Although he later became president of American Banking Association, he was disbarred in New York on January 11, 1989, after conviction on tax evasion of $240,000 from 83 to 84, and having operated a illegal bank which cost investors some $4.4 million. So that's the conclusion of chapter 3 tonight. I hope that you enjoyed it. Again, it tells me simply how what's going on is lawyers are simply just making laws and regulations. And so what they're doing that. And so they can, which is not their job. But most lawyers also are senators and representatives, you see. So they make laws. You see, that's the problem. But if people would go back and research this missing 13th Amendment, it would prohibit all lawyers to even be in power in the Senate or in the House of Representatives. They couldn't be in that position. I've done a video on that. And I don't understand why people don't want to be aware of these things, because the sad part simply is if people are aware of this, they can do something about it and say, excuse me, we did pass this thing and it has been proven. But we have corrupt men in office in all areas. And the corruption is simply rampant in this country. And it's costing people not only their lives, their enjoyment of lives, but it's actually also costing people who are the poor, who are the ones who actually get raped by these lawyers. So I appreciate you being here tonight. This is chapter 3 of The Rape of Justice by Eustace Mullins. Again, in my opinion, the two best writers, and I think I'm going to look in this particular book that he's mentioned here. I thought was pretty interesting because I've heard of his name. Fred Rodell was a professor in law, and I think he was either at Yale or Harvard University, and he was completely angry with what was going on because he realized something was wrong. And in reality, he wrote a book about it. And I think he wrote a couple of books on that. So we'll maybe look into that particular information in the near future also. So thank you for being here tonight. Thank you for listening. Hope that what you've learned tonight will help you in the future. Again, you need to have eyes to see and ears to hear. Thank you, and you have a good night, and take care.